Well, good afternoon, everybody. Almost good evening, actually.
Happy
welcome.
Friday.
Happy Friday. It's almost the weekend. This is Craig Aronoff and Travis Copenhaver from the Cannabis Legal Group. We come to you on a late Friday afternoon, which is unusual for us. Normally it's a morning show, but due to our schedules today and the chaos that's going on around town with different, actions and fun in this industry, chaos in a good way and sometimes bad, but
better late than never.
yeah, absolutely. So we're here today to talk about a few different items. Before we get too far along, please like us, share us, ask questions. Hi guys at Michigan Clear Capital, thank you for watching. We do appreciate the feedback and the questions. In fact, I think Travis and I are pretty proud to announce that we're going to be likely having some guests on our show over the next several months and whatnot. We're doing our best to maybe provide some diversity and get some other opinions and bring in some other insight in the industry.
Yeah, it's our goal to really bring in some different viewpoints because you hear from us every week, and we're attorneys, so you're going to have an attorney's perspective on all of this. So we're going to try to bring in some other elements and factors to the way the MMFLA works because, well, clearly there's a lot of work that you're going to be wanting an attorney to assist you with. There's other moving parts to this whole puzzle as well.
Yeah, and we've had the pleasure and the honor of working with a number of different of our colleagues, a number of different industry. We know that the statute, the MMFLA, requires operators to have various things such as insurance and whatnot. And so we're going to do our best to kind of bring in the outsiders to come and sit with us. We'll throw in some questions and answers and kind of have a nice conversation around this industry so that we can provide a more well-rounded show for our viewers and those that are watching and trying to learn about this industry.
Right, and we'll still be going over, news as it comes out, updates, if things come to light that warrant discussion, we're not going to be avoiding any of that. So expect a lot more of that, but, just with a little spicy extra new feature, we're going to try
other faces, I guess, sitting in between us.
Exactly.
Right. But that's important because, you've heard a lot from us and we do appreciate the questions. And so if there's somebody or something within the industry that you're interested in having us do a show on, by all means, reach out to us through Facebook and just let us know, and we'll do our best to accommodate whatever makes sense within the schedule.
Or if you play a role in this industry and you think you have something interesting you'd like to speak with us about, we'd be happy to potentially do a show with you. So let us know. Let's
keep that in mind. So again, thank you for those that are watching on a late Friday afternoon. If you're watching us, afterwards, please feel free to reach out through the site and ask questions.
Yeah, even on this video, we try to go in there and respond if something, ask a question after the fact. So, let us know and we'll do our best to answer.
Definitely, because we know from our own trial and error and studies that the late afternoon is not necessarily the one that's most watched at the time, even though it gets some great feedback afterwards. So we're happy to continue to providing all this content through the Cannabis Legal Group. Today we're going to talk about advisory bulletins. Travis mentioned we try to stay up to date on the things that are happening within the industry. Over the last week or two, I think it's been about 2 for the full of these 3. We've had 3 advisory bulletins come out. One is a little more substantive than the others, but nonetheless we're going to address them all. I titled the show "Tips for Licensees, Dispensary Ban, and Hefe." So those are actually the 3.
There you go.
3 different advisory bulletins.
Creative title this week.
Yeah, really went out full born on it.
Yeah. And then we're going to circle after we go through those new advisory bulletins and talk about a topic we kind of teased last week: what an appeals process will look like if you get denied. Yeah,
definitely. And as you'll see from our conversation, this is another one of those areas within this whole law structure that there's going to need to be some flexibility in watching what's going on. There's definitely a discrepancy between what the statute says and the way the rules are written. I don't know if it's intended that way, but there's certainly a discrepancy there that might not let us exactly see how this appeals process plays out, but we'll do our best to describe it as we know it. And of course, be right on top of it as it goes on. So the appeal itself, we'll probably do a longer show at a later time. But for right now, we want to do the structure of it. Because quite frankly, there was a meeting, June 11th, I think it was.
Sounds right.
That's, about, you get 21 days to appeal. So those applicants that might want to challenge the way that the presumptions were made at the time of the hearing,
have a window to do that.
Yes.
So.
Yeah, so Why don't we dive right into the tips for licensees? And really, that's what this was called. So if you're on the medical marijuana page at michigan.gov, this one's called Tips for Licensees. I gotta go the other way. There you go.
That's the one we're talking about first?
Yep. And so it's color. So what they're really trying to do is show you examples of packages that are compliant and show you really examples that are not compliant, tell you why they're not compliant.
Sure.
This all follows Rule 33, Emergency Rule 33, which lays out the requirements for medical marijuana infused products. So it's really designated towards the processor license.
Right. And Rule 33 goes over not just what this advisory bulletin is on, but also how packaging needs to occur in general. So what this Tips for Licensees is really talking about is one of the requirements of Rule 33 is that your products cannot have images that appeal to people 17 years of age or younger. These are things that are going to have, association with cartoons, caricatures, toys, certain colors, designs, shapes, labels, or any kind of packaging material that will appeal to minors. And they've used some pictures to really illustrate what they mean when they say that, so, it's very, very clear.
Yeah, the most common problem that these particular packages have is that they're not opaque. Mm-hmm. So if you can visibly see that it's a candy through the packaging, right, that is probably going to be non-compliant. Right. If it's shaped like something of interest, and one of them is a lollipop, for instance, and it's clear that it's a lollipop, that too would probably be deemed non-compliant. So.
Right. So there's going to be some gray areas there, but the rule of thumb is this: if objectively it looks like something that a child might want to think is candy or chocolate or something like that, it's going to be problematic. And that's not just in the shape of the products themselves, but the packaging surrounding those products or the presentation of those materials.
Yeah, and so even the name itself of the particular, product that you're looking to have, one of them that's actually listed in here was, it's actually called Fruit Loop Treat. Right. I mean, clearly Fruit Loops are a cereal, so that's tied to
which
brand.
That's above and beyond the problematic situation you're creating in trademarks where, you probably don't have the right to call something a Fruit Loop if you're not Kellogg's cereal company. So, beyond that issue, what that image or that set of words is going to inspire in the minds of the consumer is some sort of association to children's cereal. So, that's an example of the types of things they're going to be looking for when they're inspecting your facility and ensuring what kinds of products are flowing through the system are, meeting the rules and requirements.
Yeah, definitely. And then, in addition to the packaging and whether or not it's clear and something that is something that would appeal to children, what your brand label looks like is the next thing. How does the picture look? Does it look like something fun and exciting? Basically, gray and dull and nothing exciting is what I think this the state is asking these providers to offer. But
since you happen to be on the work group, Craig, for those who didn't know, there were work groups set up with different board members. Craig happened to be on the processor work group. Is there anything that we saw make it into Rule 33 or some of the examples here that are surprising to you, or is it kind of in line with the way those discussions went?
No, it's very much in line with it. I mean, not only from the advisory bulletin, but Rule 33 itself, where it talks about if you are going to be making a marijuana-infused edible, and you got to follow food safety standards.
Right, and you see those laid out. There's requirements that whatever products you're making, if there's some sort of temperature added that you need to add, or some sort of storage that's above and beyond, that would require a consumer to apply. Like think of a frozen pizza. Like if you have to cook it or something when you receive it, it's prohibited from being a product on store shelves. It needs to have shelf life. And it needs to not be some sort of product you manipulate on the consumer end. So when you above and beyond like the things they're talking about in here, Rule 33 does lay out some guidance as to the types of processed materials you can be creating as a processor licensee. And it's important to remember that both the statute and the emergency rule and the advisory bulletins we're going to get afterwards do make it very clear that it is a processor that is supposed to be packaging these materials. So if there are marijuana infused products, you're not really allowed to be putting your own packaging at the the provisioning center receiving end. These packaging is kind of the responsibility of the processor. So
I think that's a great point. I mean, the statute makes that clear, as well as, what the law allows for each of these license types. So if you're a provisioning center and you want to come out with your own branded, infused products, you're going to need to work on a license agreement with a processor and allow the processor to be the producer, and then you bring it in under your label and sell it on your shelves.
So that can be accomplished through contracts and licensing agreements and things, but just understand the responsibility-wise, under the rules, under the regulations, our processors package marijuana-infused products.
Yeah, that's a great point.
There's some unanswered questions about what do you do with the flower, like who's packaging that?
Well, no, I think the grower is the one that's going to be responsible.
That would make sense.
So, right, but there are questions as far as, well, what if I want to do a CBD, infused keef roll joint? Right. Well, that's now a process thing because you're taking the flower. But we're getting a little astray from the tips for licensees. But you can see the depth at which this conversation can really go. Right. And I think it's important that in each of the license types, we understand the lane you're in and where the boundary is, where all of a sudden your activity is a different license type. If you're doing an unlicensed activity, that is cause for you to lose your license. So be wary of where those boundaries are. There's a mention too about products being pulled from the shelf. So keep in mind we're in this temporary attestation period. So if there are a store we're talking about, they're operating with this Rule 19 attestation that we talked about last week. Mm-hmm. The products on their shelves generally are not from a licensed marketplace. So we got to be very careful about what we see today and how we'll make this improvement towards the future tomorrow when we have these licensed products. But for those of you that are selling into this market and producing these products, you got to follow the rules as they are, or your product's coming off the shelf, the name of your brand is now known to LARA as somebody to look out for, and that can't, I would think, be a positive for you in the end. I think that's going to be troublesome. Right. So
we did get a question about expiration dates on marijuana-infused products, and I think the rule of thumb so far would be it depends on the type of product that you're looking at. If that product safely would require some sort of expiration date, given the other ingredients within it, then yeah, I'm sure that they're going to want to see that. If there's something that would spoil, in a long-term, storage of those products. But, some products might not necessarily require it.
And when we were talking in the work group, we went so far as to say, well, what happens when you bring the flower into the facility and it's, and it's still in your inventory before you actually make the infused product out of it? That flower itself needs to be stored appropriately and everything. And so we're going to see that, the production line from the moment it hits the loading dock all the way through the moment it's tested on the way out the door, the SOPs and the standard operating procedures that the companies need to follow and the compliance they do are really dependent upon what they're doing at that time. If they're edible and they're making brownies, then they got to follow certain post-serve, conduct, as well as, all the different, IOSHA and IOSHA and all the different food safety standards. If it's a vapor pen and you're using some kind of closed loop system or whatever it is, again, you got to follow the ISO and all the different standards that are for those engineered products.
And remember, we might not necessarily, we're working on our emergency rules, so some of those things might be further fleshed out. Remember, you can always go above and beyond as the operator too. If you think, an expiration date would be appropriate to maintain the quality of your product, I can't speak to whether or not it is required. That's something we can certainly circle back on. But let's imagine that you as the processor understand that after a certain amount of time, the quality of your product will fall off. So it might be appropriate for you to choose to do that anyway, because you don't want that quality drop to be associated with your products. It's going to have a retail impact, and you want to maintain your quality control regardless of the rules and laws require you to do so.
I think it's a very, again, this is cannabis business. We're talking about the business aspect of being a processor. Your widget is the marijuana-infused product. You're actually in the business of providing, something that's a consumed product in the marketplace. Mm-hmm. You should know whether or not your vacuum sealed products can last longer on the shelf than those that are, ziplocked and so on. So
that's part of building your brand. If your brand develops a reputation for being stale and not fun to consume after several months, then you're going to have a problem.
Yeah, and so you know what? Now's a great time, by the way, if you're getting into this industry and you've already started to invest in your equipment. You don't have to use the marijuana-infused component, mm-hmm. but you can start to actually test how long your packaging will work and do the studies in the background to find those partners and vendors that will provide you the packaging so that you know exactly what those timelines for
just be careful
consumption should be.
Do so legally if you're
Well, definitely, again, it all is maybe with, using a different product altogether, and everything in it is the same as your ingredients but the infused part. There's a question that Carrie had asked on there about why not go after the manufacturer. My opinion at this point, again, time will tell. We've generally thrown out and given you what our advice is, and whether you're sitting here as a client or otherwise. I think brand name products that are on the shelves are going to have issues when their brand seeks licensing.
Right.
Unless it's done through a caregiver who has the credentials to do it and stays within their license that is allowed, 72 plants, no more than,
We really took a deep dive on some of those, elements, those moving parts that would give us a more fleshed out answer to that question in the last video. And I'd invite you to go watch that one. We really talk about what temporary operators, mean to us, and that kind of is reflective of the question you're asking.
Definitely, and I do think that in the end, if you're the one trying to put these on the shelves, and this is a place that isn't yet licensed, the regulators are coming in, not one or two at a time, but maybe as many as a dozen, and they're coming through these facilities. They're inspecting it. We already know they're pulling product off the shelf. Is it your product you want pulled, or do you want to maybe wait? Exactly. And so be wise as to how you're bringing your product to market. So that actually is a great tie-in to, I guess, the appeal process, because you're going to find yourself in maybe a position where there's a reason for a denial. But just real quick, we have two other advisory bulletins that...
so the next one I definitely saw get some buzz in reaction to, but there's an advisory bulletin clarifying the terms provisioning centers can and cannot use when they're referring to themselves in legal capacities. And one of those terms, along with many others, is the word dispensary. So that is something that is been law, as it's moved forward. It's just something that's not usually enforced. And I am certainly guilty of saying dispensary and provisioning center interchangeably. Yeah. But, in addition to that, words like pharmacy, apothecary, drugstore, prescription, medicine store, there are prohibited words in law, and dispensary is one of them, as it is associated to provisioning centers.
It's really, which is shameful. I mean, I understand why we can't use it in our advertising, because you can't call yourself a dispensary, but this is going so far as to say, let's take it out of the nomenclature altogether. Right. In reality, and around the country, most retail outlets for cannabis-infused products and cannabis are dispensaries. In Michigan, our license is for a provisioning center, but that's something we in Michigan will find unique, like a secure transporter is unique. So it is what it is. We'll deal with it. We'll be happy doing it. We'd rather have full-run provisioning centers that are approved in all our cities than, complain about not being able to call them a dispensary.
Right. And then the key there is in advertisement, which is going to be really difficult to enforce. What does advertisement mean? Obviously, if it's something you as the operator are creating and have agency over, just don't use the word dispensary. But they're never going to stop people from using that term. It's basically Kleenex as to tissues, right? I mean, it's the word everyone understands. And, from a legal perspective, just use provisioning center if you're a provisioning center. And, if everyone else calls you a dispensary, that's great. The same way we spell marijuana with an H, technically, in Michigan, and everyone else uses a J. Everyone knows what you're talking about.
Right, we got to be different in all facets.
Exactly. So,
and speaking of different, here's one on Hep A.
Hepatitis A.
Apparently, this is basically just a public announcement to just, look out for the fact that there is an outbreak of hepatitis A in Michigan. It's not necessarily related just to marijuana.
Right. I've not heard any specific report about hepatitis A being found in marijuana. It might be out there. I think it's just, as the Bureau of Medical Marijuana Regulation, they're acknowledging the fact that this particular virus could find infection and habitation in cannabis, and you should be careful to ensure the safe handling of these products as this industry evolves, not only for hepatitis A, but in general, and it's kind of LARA's job to notify the public of these risks. So it's nothing to criticize them over. I don't think there's anything specifically generating. Marijuana really needs to be different about hepatitis A than any other similarly situated product.
And to be honest, and we haven't really researched it to know, I don't know that the same advisory bulletin wasn't sent through 10 different departments at LARA to different areas where people may come into contact with similar things. It happens to be the Bureau of Medical Marijuana Regulation tapped into that and said, you know what, if this is something that could survive on the marijuana plant for up to 60 days,
right.
and it could potentially be something that's consumed, through touch, smoke, whatever the case may be, then they were wise to do the public safety announcement.
I applaud LARA for doing it. That's their job. This is what they're supposed to do. We're all very focused on getting licenses and the challenges and the backlog and interesting decisions that are made. But as we evolve into a more mature industry, this is what you're going to see from LARA. That, hey, there's a risk for E. coli outbreaks. We're going to have an E. coli bulletin. Hey, there's a risk for, just listen. I mean, that's what LARA is supposed to do. They're supposed to notify the industry and consumers of these types of risks, and we expect to see a lot more things like this.
As with many things that Travis and I are in agreement on, we have done our best to really complement LARA where we should, and take them to task where we should as well. And this, again, is another area where they're showing us how they're going to continue to not only protect the marketplace, but the consumers themselves, and the operators and those that are involved in the industry. And so I applaud them as well for doing that. LARA's job is, and we keep saying LARA, but let's say the Bureau of Medical Marijuana Regulation. They're the department in the Bureau that is collecting the applications, they're doing the background checks, they're doing the deficiency letters, they're interacting back and forth with applicants and applicants' advisors and attorneys like ourselves, and the interaction with them, time and again, everyone who's dealing with them agrees that they've been doing a really good job communicating and working back and forth. Where we have a problem is that when those reports are made and they're submitted to the board, we're not always finding that the board is necessarily agreeing with the recommendation, at least as we understand it. But we've seen a handful of decisions now that, quite frankly, at the time of the hearing seemed questionable, seemed really dubious.
And I will say, we don't have the full context. We mentioned this the last time it came up. There's a report that is not necessarily public record. So when there's a discussion on some specific item of that report, there might be something we're not privy to that, warrants the conversation to go in a direction that, it did. But taking it at face value, we see that, certain comments were made that seem to open the door to, was that an appropriate point of view to base the decision on, and is that potentially a decision that opens itself up to an appeal, giving that applicant the opportunity to put its point of view, its evidence on the record, and perhaps have its position reevaluated. So,
David, you made a good point. There's a gentleman that made a comment here just talking about the propagation of our marketplace, and we'll dive back into the commentary, but if you're the first provisioning center who gets a license, you don't have anybody to ship your product to you, whether or not you have a processor or a grower yet.
You have a grower across the street, but if it's across the street, you can't get it yourself.
Carry it in. So, the entire network has to be created. And there is a question, and we thought maybe 8-10 months ago that maybe cultivators would be given a higher concentration up front. But we're not actually seeing that quite yet, and that's one of the reasons why caregivers are allowed to bring their product in for 30 days after licensing.
Right. And then some of that might even be another topic we can discuss
definitely.
in a second hearing. So.
But let's chase it back to the other one where we're talking about the appeal process now. So the board has made its decision. You're feeling aggrieved. What do we do next?
So the very first thing you should know is you have 21 days to initiate this appeals process. So if you take a couple weeks to decide if you want to or not, you should be aware of that there is a clock that's ticking from the moment you are noticed that the decision has been made. After that, then it's there's a process you go through to actually implement that appeal. So it starts with in notifying, hey, I'm going to appeal. And then it gives us some timelines as to how long you have to put evidence together and how long the state has on its end to do its response to that as well.
So I mentioned earlier in the show that there's a bit of a discrepancy, and so as we read Section 407 of the Act, the MMFLA, it discusses how after denial, the board, upon request, shall provide this public investigative hearing. So in other words, the statute says the board, upon request, will provide a public hearing.
And it goes further to say that the applicant will be given an opportunity to present testimony and evidence to establish its suitability for a license, and then that the way the sentence is constructed, it applies to the board.
Right.
So, that's what the MMFLA, the statute itself in section 407 part 3 states.
Now, when we read the rules, however, and first of all, let's just say the idea is that the person that denied you now is going to give you a hearing to come back, and your sole purpose is to convince that one person or the 3 or whatever it is that voted against you that you get to come back and provide testimony.
Right, because as anyone who's seen these decisions be made, is the applicant does not have a seat at the table. It is a presentation of materials to the board discusses it
and the presentation is the report from LARA that
exactly.
we haven't seen yet. And so, of course, we assume that report will be provided to the applicant so they can maybe utilize what could be positive information that the board simply ignored.
Or correct something that might have been reported in error.
Yeah.
Or at least provide the context to put that in a different light.
But ultimately, there's a question of due process that concerns me in that, I think you should have the opportunity to take an appeal to somebody else to review the conduct of the first party.
Right.
And this is really just a motion for reconsideration, for lack of a better description. Right. And so...
Barton here.
Yeah, right. We've litigated a bit here.
Sure.
But, that's the point is that when we read the rules, however, the rules are seem set up, and we're talking about rules 45 and 46, that really kind of lay out a process that says once you make your request, the Administrative Law rules kick in, the Administrative Procedures Act kick in. So within the rules is a statutory, in fact, actually the Administrative Procedures Act is in the statute too.
Right.
But, the rules kind of give you the idea and the opportunity to actually have a panel of judges, administrative law judges, that could have a full docket of other matters, and now including your marijuana matter, and they would have the ones that would render a decision on clear and convincing evidence whether or not the board gave you the right decision.
So let's focus in on that. We'll go back to law school 101. So there are 3 traditional standards of evidence. There's beyond a reasonable doubt. That is the criminal statute, or the criminal burden of proof. There is...
well, what does that mean, though? Beyond a reasonable doubt simply is no one would disagree. There's no doubt at all. You've proven to virtual certainty, actual certainty that this is true.
Right. So I always say that is the goal line when if you're playing football, you have scored a touchdown. That is beyond a reasonable doubt. In most civil litigation circumstances, it's a preponderance of the evidence. That means you've passed the 50-yard line.
More likely than not.
You're on a scale, you or slightly more, you win. Clear and convincing evidence is somewhere in between those 2 standards. It's probably the one that
20-yard line.
Yeah, it's somewhere, within field goal range is what I like to say. So, it's more than 50-50. It's less than scoring that touchdown. But it is a high level of, it is an elevated burden of proof, which means that, traditionally when we refer to burdens of proof, we're talking about costs and difficulty. So, if you have a 50-50 shot in this situation, it's a risk and the cost associated with taking that risk, you can kind of make an estimate about whether it's worth going through that proceeding or not.
Right.
Clear and convincing evidence is a hard burden to meet. It requires you to maybe be right, maybe be wrong, and it leans your way. No, it requires you to be very clear and convince an objective party that you are correct. Now, it's not beyond a reasonable doubt. That's even further. Right. But, it's a very high standard to meet.
And this burden is carried not only through this administrative law, if that's what the hearing is, and notice I say if, because we got to see how this process plays out eventually as they move forward. But ultimately, reading the rules further, it comes back to the board. So the law judge makes a decision, and let's say they say the board was wrong, and we have a law report that says they should be approved, and then the board says, yeah, that's all fine, but we presume this, and no.
Right.
So we're still a little skeptical as to, I think, is that a fair statement, as to exactly how that process will play out. But you got to follow the rules, you got to file it timely, you got to provide that clear and convincing evidence, and you got to build your record to perfection to make sure that you have that best opportunity.
And then you have to make an agenda of the board, which might be problematic as well. So everything can go your way, and you might still be waiting perhaps months before the board has some schedule availability to take on that consideration.
Yeah, because we already know what the board meetings are. We just don't yet know what the agendas are. And rumor has it that we might see, say, 30 on the next board meeting. And there's 500 in the queue, so they're taking on a little less than 10% each time. We got a ways to go. Hopefully, we'll see them add some meetings. Hopefully, we'll see some further indication of they're going to be moving forward on these a little quicker.
Right.
But again, this is just something we wanted to bring up because as we have applicants that are getting close to the time where they need to file those appeals, and we're going to start to see that, like we have, the applications go in, and we have deficiency letters that people have brought to us. We've talked about in the past. This is the next thing that's going to come up,
Right.
and we want to be in front of that here at the Cannabis Legal Group and helping people understand they too need to be prepared for it.
Right.
You got to build your record.
And not to maybe get us talking too much longer, but to just give you my final thoughts on what this means to me is your ability to appeal and the time that you can appeal is really going to be kind of is that worth it for you on a case-by-case basis? If you're in a municipality where your local approval has some sort of window that's closing, or if someone's waiting in line to take their opportunity behind you if this community has capped your license type, having to appeal, the time it might take to ultimately get that decision, might kind of tie your hands about what your options are going to be. If you decide you want to, okay, maybe we know we got denied because of someone who was part of our team that's problematic, restructure, put a different step one application together and try again, or an overall application and try again. That might also have impacts on your local approvals. If one type of company was approved at the local level and there was some sort of material change, that might not be good enough for that local municipality to maintain that approval for your application. So while some people might have to look at this appeal process differently than others, they might have to appeal because if they ultimately lose, they might lose their local positioning, or they might not be able to take advantage of the investments and opportunities they made up until that point. So I think that's why it's really troubling to us when we see some of these applicants perhaps being pushed into where their only choice is an appeal. It's our hope that as the board continues to do this more and more often, and again, we don't get the whole story, so there might be some issues or context that we're not privy to, but there's probably going to be reasons for applicants to explore this appeals process, because otherwise they're going to be in those situations where you're going to really be sacrificing a lot of the time and investment you've taken to get there.
I agree with that, and I just think that people are putting their blood, sweat, and tears into these companies. They're putting their livelihoods into these companies, and they're wishing on a hope that the board is going to say yes and not scrutinize some past activity related to this industry.
Right.
And what we're seeing from them is that they're holding it against a lot of people, and so we want to be sure that people can cover their transactions and they can account for changes in their company. They can show that the change in how the structure and operation of the company is supported by that change. And again, just trying to work with LARA, be as communicative as possible, get feedback on questions, don't assume things with them. That is part of this record in the end. This is part of that record. You're building your case to support that denial was wrongful. And whatever is in there is what you're going to have to that benefit. So again, just be smart through the process, answer questions transparently, and patience will be a virtue throughout.
Yep.
Yeah.
And to their credit, the entire Bureau of Medical Marijuana Regulation is doing its best given a lot of challenges. They have tight deadlines. They are administrating a brand new program. We have a board that's unpaid volunteers. So let's be realistic about what they're trying to do. And we have a very excited, very motivated, and very mobilized industry trying to flow through a narrow path forward. They can only do so much, and that's going to come with some aggravation, some disappointment, some frustration, and perhaps some errors along the way. So,
and probably a lot of excitement in the end when these licenses issued. So, we're excited to continue to see how this market develops. This is not meant to be a negative type of conversation. It's to be prepared for what might come, and and just do what you can to stay above the fray. So,
and appreciate what this process looks like if you're about to embark on it. So you take the time to do things the way that they need to be done, so you hopefully don't have to deal with an appeals process.
Yeah, when they ask you for something, don't ask why. Just get it to them.
Yeah.
All right. Well, we've taken up. We've taken up a little shine today. We very much look forward to providing the content. As I said, we're going to have some new and different shows coming up in the near future. I believe next week we're scheduled to be in the morning, hopefully.
We'll see.
We'll see. But we'll continue to do our best to stay in that realm. It's just Fridays can be kind of hectic, but we appreciate those that have watched. We appreciate the questions. Continue to ask those if you've watched this after the live show is over. Travis, myself, Nick, and Barton will all do our best to get back to you. And from Craig Aronoff,
Travis Copenhaver.
Thank you very much. Have a great weekend, everybody.
Thanks, guys. Enjoy the first of 2 4th of July weekends.
That's right.